Rob is a professor of human rights law at King's College London, where he has taught since 1991, and his teaching and research focuses on human rights law, anti-discrimination law, European Union law, a little bit of contracts, I guess.
No,
not so much anymore.
In the distant past.
Right. So he, is a Londoner and has been for some time, but he's also a Canadian and originally from Calgary, and did his BA at the University of Alberta, including a year in Quebec City at the Université Laval. And he earned his LLB and BCL in the national program, as it was then called, at McGill University in 1982, and received his DPhil from the University of Oxford in 1993, and also practiced in New York for a handful of years. We're very fortunate to have Rob here at the end of a whirlwind, or I think it's towards the end of a whirlwind Canadian tour.
I'm taking a break tomorrow. I was supposed to go to Western, but that didn't work out. So.
Ottawa on the weekend, speaking at a conference. McGill on Monday, Queen's yesterday, Osgood today. He's just taken the train in from Kingston. It was delayed, hence the breathless arrival a few minutes ago, which involved taking a cab up, 427, 401, 400. So welcome to the delights of Toronto traffic. We've all been very fortunate over the years to benefit from Rob's outstanding scholarship in the area of anti-discrimination law, with a particular focus on discrimination on the basis of sexual orientation. I've relied very heavily on Rob's work over the years. The book that you co-edited in 2001 on legal partnerships, same-sex partnerships, was a fabulous contribution to that area and to developments around the world. It seems wherever there's something going on in relation to equal marriage or the rights of same-sex couples, Rob's there, filing an intervenor factum, presenting expert evidence, and doing all of us who are interested in the area the great service of providing us with digests of all the latest developments around the world, for which I'm very grateful. He's also, over the course of the last almost decade, taken a great interest, as any human rights scholar does, in developments in Israel, Palestine, and that's what he's going to be focusing on in his talk today. The title of his presentation is Israel, Palestine, Is it Apartheid? And is boycott justified and legal? And this is a presentation that is related to an article that Rob has recently published on this topic in the King's Law Review, which I commend to you. Please join me in giving a warm welcome to Professor Rob Wintemute.
I'm supposed to, can you hear me? I'm supposed to have a microphone, or maybe that's for recording. Anyways, is this better? No? Is this on?
Which is for the recording, the handheld or the lapel?
Lapel. Okay, yeah. Well, thank you very much, Bruce, for that very kind introduction. It's a pleasure to be back at Osgood Hall Law School. My last visit, when I was here for my last visit, I had a very grand title, which was the Bertha Wilson Distinguished Visiting Professor of Human Rights Law. So I have fond memories of that 2-week period. But it's also a pleasure to be at the site of the historic conference on one state or two states for Israel-Palestine held in June 2009, which I unfortunately missed. I was occupied in London, couldn't come to it. Bruce mentioned my work on LGBT human rights, and I just mentioned last year I was a candidate for the new position of United Nations independent expert on sexual orientation, gender identity. I was one of 5 candidates they interviewed, but I didn't get it. They appointed a man from Thailand. There was a strong preference for someone from Asia, Africa, or Latin America. He has just resigned for health and family reasons. So I have until the 11th of October to decide whether to apply again. So we'll see. Actually, I'm here today because of another UN expert, Professor Michael Link of University of Western Ontario, Faculty of Law, who is the United Nations Special Rapporteur on the occupied Palestinian territory. And he inspired me to extend my stay in Canada. So I think that's all by way of introduction. Now, I've been starting this talk with a T-shirt and a video. So let's see. When I first started I made my debut on this topic in March 2013 at McGill, and I was talking about the A word in relation to Israel-Palestine apartheid. And that time they had a security guard posted outside. Fortunately, nothing happened. But so this time I'm moving on to the A word plus the B word, boycott, okay, which I can illustrate with this T-shirt made in France. So you have to read it as Boycott Israel Apartheid, and then you flip it over and it says Justice en Palestine. Now, I heard that a woman in France had been arrested for wearing it, so I immediately searched on the internet and ordered one for my collection. So let's turn to a video with some images. So we hit. Right, so my talk today is about why are people using these words, apartheid and boycott, in relation to Israel-Palestine. Now, to desensitize the word apartheid, I think it's important to know that it's actually quite commonly used in debates in Israel. And two people who've used the word are former Prime Ministers Ehud Barak and Ehud Olmert. And they both warned Jewish Israelis that if Israel did not withdraw from the West Bank, and people in the West Bank did not have the right to vote in Israeli elections, that would be apartheid. So my article is basically 40-page legal development of that proposition with footnotes. So describing the situation as apartheid involves moving from the traditional analysis and description, which is one of occupation. So the question is it temporary military occupation or permanent racial apartheid? And this actually involves moving from one body of international law to another, from international humanitarian law, which governs military occupations, to international law against racial discrimination. And what I've discovered in the course of thinking and writing about this topic and presenting is that we have a missing link. If you think of these two bodies of law as two railway tracks, what's missing is the switch. So railways usually have a little curvy part that allows a train to go from one to the other, and that's what's missing. So that's actually what I propose in my article, and what is novel for public international lawyers, of which I am not one. The problem with using the term occupation is that occupations are meant to be temporary. So you could survey the history of occupations and find lots of examples, but one I picked was the United States occupation of Japan, which started in 1945 and ended in 1952, 7 years. So Israel's occupation of the West Bank, including East Jerusalem, and external control of Gaza is now 50 years old. So the real problem here, I say, is we have an obsession with theory and purity on the part of international humanitarian law. And this stems from the post-1945 principle that territory cannot be acquired by force, ever. So the approach of international humanitarian law is that the West Bank, including East Jerusalem, are occupied territories, do not belong to Israel, and can never belong to Israel without the consent of the people there. So the theory of international humanitarian law is that there's an incentive to end the occupation because it costs money. You can never acquire the territory, and there's the key prohibition in the Fourth Geneva Convention of 1949 against moving your civilian population into the occupied territory. Now, because Israel has defied that provision, ignored it since 1967, produced a population of 500 to 600,000 settlers living in settlements that are clearly illegal under international law. There has been no incentive to leave. So international humanitarian, the big problem in international humanitarian law is that it does not set a deadline. So technically at the moment you can't say the occupation is illegal because the assumption is that you can occupy until there's a peace agreement, and then after the peace agreement you withdraw. So that's the problem. So I would say international humanitarian law is obsessed with this ideal theoretical approach that no annexation by Israel of East Jerusalem and the West Bank is valid under international law. They must withdraw at some point, but we don't know when. It could be in another 50 years, 100 years after that, etc. Now, some scholars are trying to reform the law of occupation. Professor A.L. Gross of Tel Aviv University has just published a book called The Writing on the Wall, where he argues for a reform of that area of law. And Professor Michael Link told me in June that his next report would adopt this analysis and argue that the occupation has become illegal under international law because of its duration. Now, I greatly respect both of them, but I think for political reasons or with regard to political impact, this is a waste of time. I don't think it will make any difference because we already have a judgment or advisory opinion of the International Court of Justice from 2004 stating very clearly that the settlements are illegal, that the West Bank wall is illegal, and that has had no effect on the policies of the government of Israel. So I don't think that upgrading it from occupation to illegal occupation will make a difference. So that's why I think we need to switch tracks. And what I've proposed in my article is just to draw a line at 20 years. After 20 years, international law doesn't like the fact that you're still there and doesn't like acknowledging your de facto sovereignty and control over the territory. But I call this the lesser of two evils approach. We will deem it to be a de facto annexation, which is certainly what I saw when I was in the West Bank in 2009. And this triggers an obligation to grant citizenship and the right to vote in your elections. So I see this as combating the greater evil of indefinite racial discrimination in access to citizenship and the right to vote, which is greater than the lesser evil of de facto acquisition of territory by force, to which international law is opposed. So that's what the chart on page 1 is about. So flipping over to page 2, the second heading, I'll take the comparable occupations first and then go to Stephen Harper's quotation. Typically when you criticize the occupation, call it apartheid, call for boycott or whatever, the response you get is, what about other occupations? Why don't you propose the same? Why don't you use the same description for Tibet, Kashmir, Western Sahara, Northern Cyprus. All these situations come up. And I started thinking about them and looking about them and wondering, so is there a difference between those occupations and Israel's occupations? And the difference I saw was that those are all situations of de jure annexation by the occupying power, which might be invalid under international law, but that is the reality on the ground. De jure annexation combined with a grant of citizenship and the right to vote. So if we take Tibet, people in Tibet, as I understand it, are citizens of the People's Republic of China, and they have the same right to choose a political party other than the Communist Party in elections as people in Beijing. So an equal share of no democracy is no democracy, but at least everyone's in the same boat. If you go to Indian-controlled Kashmir, you have the majority of people not wanting to be in India, but they are citizens of India with the right to vote in Indian elections. Northern Cyprus, Turkey has set up an entity known as the Turkish Republic of Northern Cyprus, which is not internationally recognized. But if you're living there, I presume that you can get a travel document with that name on it. It might not get you across many borders, I don't know. But you can also get a passport from the Republic of Cyprus, controlled by Greek authorities to the south. So it's not a comparable situation. In fact, Cyprus is a two-state solution. You have one de jure state, one de facto one, with ethnic cleansing on both sides. So the Greek minorities in the north fled to the south, the Turkish in the south to the north, etc. And current negotiations are about trying to get back to a one-state solution. But it's not comparable in terms of the denial of citizenship. And Western Sahara, I knew nothing about Western Sahara, did a little reading, and came across the website of the government of Morocco. And there's a nice map with the territory of Morocco, including Western Sahara. There's no line. And presumably anyone living there is a citizen of Morocco. So that is the difference. Now, the other thing I'll mention at this stage is, in my analysis, I don't rely on the International Convention on or against the crime of apartheid, which Professor Richard Falk does, Virginia Tilley, others have relied on that treaty. The reason well, there are basically three reasons why I don't. One, it's very complicated and seems to be tailored to the conditions of South Africa. Two, it hasn't been ratified by as many countries as other international human rights treaties. If you check the ratifications, most EU countries have not ratified. Canada has not ratified, nor the US, nor Israel, nor even South Africa. So to me, that undermines it. And third, I don't think the concept of crime is useful in this situation, because it gets some activists cited. Apartheid is a crime against humanity, listed in the Rome Statute of the International Criminal Court. We'll talk to the prosecutor in The Hague, and that's the solution. We're going to get Mr. Netanyahu and other officials of the government Israel arrested and put on trial in The Hague. And I think it's completely unrealistic. And I think the notion of crime against humanity just makes Jewish Israelis more defensive. So I prefer, as an anti-discrimination lawyer, to view this as a tort, a civil wrong. And our goal is to bring it to an end as quickly as possible. And our objective is not to put people in jail. Even South Africa did not have post-apartheid criminal trials. They had a Truth and Reconciliation Commission instead. Okay, well, let's turn to Stephen Harper. Top of page 2. He gave a speech in the Knesset in Israel in 2014. So he says, some openly, like Professor Robert Wintemute, call Israel an apartheid state. Think about the twisted logic and outright malice. A state based on democracy founded so Jews can seek shelter from the worst racist experiment in history, is condemned in the language of anti-racism. It is nothing short of sickening, but this is the face of the new anti-Semitism. It targets the Jewish people by targeting Israel and attempts to make the old bigotry acceptable. Okay, well, I would be nice someday to have a chance to chat with Mr. Harper, but I don't think that's too likely. But the first thing I would put to him is that he's assuming that victims of racial discrimination can never become perpetrators of racial discrimination. I first saw those words used in a book by George Soros, which I need to look up. I was just browsing in a bookstore, but I'm pretty sure he had a chapter where he talked about Israel as a victim turned perpetrator. And I think that is what this accusation of malice relates to an assumption and a chain of logic, which is Israel is good for the Jewish people. People who criticize Israel hate Jewish people. And that would be the only motivation for criticizing what you see are objective human rights violations. And I reject that logic and assumption completely. Point 3. In my article, I have 3 quotations of this kind. Another one is from the Ontario Legislative Assembly and one from the California Legislature. In the Ontario one, at least in the debate or the motion, there's a statement that apartheid was a unique situation that only ever occurred once in history. This was actually, the motion was triggered by Israeli Apartheid Week at Toronto University or Ontario universities. And it should never be used in relation to any other situation in the world. And of course, I don't agree with that. Linguistically, apartheid means apartness or separateness. There's no reason why it cannot be applied in other situations. And this is where I think it's important not to get bogged down in the detail of the Apartheid Convention and try to tick off boxes and say, this is present, that is present. I think it's better just to ask what was the core of South African apartheid. And I would argue that it was racial discrimination in access to citizenship and the right to vote. Everything else was secondary. I have a fridge magnet at home from the Apartheid Museum between Johannesburg and Soweto, and it says Europeans only on a park bench. Okay, so people point to features like that. There were bans on interracial marriages, all kinds of features. But the core was the denial of the right to vote, and that was the last part to be dismantled on the 27th of April, 1994. That day, I recall hearing the most famous living graduate of King's College London, Desmond Tutu, being interviewed by the BBC radio. And he was in a queue waiting to vote, I believe, and was very excited, jumping up and down, giggling, because he was in his 60s and voting for the first time. Yeah, so the question becomes, now this is where the government of Israel will say this has nothing to do with race, it's all based on citizenship, a legal status. All these practices you're condemning, they apply to people who are not citizens of Israel. And they do not apply to people who are citizens of Israel, nothing to do with race. But that's where you have to interrogate Israeli law on immigration and citizenship. Is there a link to ethnic origin? So if you look at the law of return and the nationality act, the nationality law, what you see is the difference in treatment by Israeli law. So a person who is considered ethnically Jewish by the government of Israel, this means having one parent or one grandparent that is considered Jewish. And remember, this is ethnic because it has nothing to do with religious practice. You can be an atheist and qualify, okay? So if you qualify as Jewish, you have an automatic right to move to Israel, take up Israeli citizenship, and vote. And this is regardless of whether you've ever been there or whether you could point to any ancestor who's ever lived there. Now, if we take Palestinian Canadians, of whom there are many in the Toronto area, they might have been born in British Mandate Palestine, or their parents might have, or their grandparents. And they have all the documents to prove it. So many have, or some have the key to their house in their village. So if they apply, different rules apply. You see, it's actually what I, as an anti-discrimination lawyer, I'm looking for, so how do they insert the discrimination? And it's done in a very subtle way. It's a physical presence test. So a Palestinian only qualifies if they were physically present from May 1948 to July 1952. Okay? And that's the problem, is at that time you had a massive expulsion and people were not allowed to return. So post 1952, it becomes impossible for you, your children, and grandchildren to qualify. So this incorporation of ethnicity into citizenship law, with regard to a group that has an equal, if not stronger, claim to citizenship, is direct racial discrimination. And we have a decision to this effect from the UK Supreme Court in 2009, not in the context of Israel-Palestine, but in the context of a state-funded Jewish faith school in London. A Jewish boy applied for admission, and the school said, yes, your father's Jewish, but your mother isn't. She's of Italian ethnicity, and her conversion to Judaism is considered invalid for the purposes of admission. And the majority of the UK Supreme Court said this is direct racial discrimination because they were using this ethnic criteria based on ancestry as opposed to a religious criterion, which would have been permissible under the legislation. If they based it on religious practice, you and your family do not practice Judaism, you never go to synagogue, you do not celebrate high holidays, that would have been legal. But basing it strictly on who the mother was not. Okay? So I'll try to speed up here to allow more time for discussion. Now, when we use the word apartheid as Canadians, we have to remember the saying, people in glass houses shouldn't throw stones. And so way back in 1989, I was sitting in Wilson College, Oxford Common Room, reading an article by a South African commentator who said, the only reason that Canada, the US, Australia, and New Zealand believe in one person, one vote is because the percentage of their population that is indigenous is as follows. And he had 4 numbers, all below 10%. In South Africa, it's 80%. This explains everything. And at the time, I just thought, oh, you horrible, racist, white South African man, how dare you suggest there's any similarity between South Africa and virtuous Canada. But it took me a few years to process that, and I realized he's absolutely right. So it's only by the grace of numbers that Canada did not go that way. So you have to, if you're comparing Israel-Palestine to Canada, you have to think of Canada, 36 million people, 18 million indigenous, and of the indigenous, 4.5 million are allowed to vote, and the others are not citizens. And we'd have a lot of expelled indigenous people in North Dakota and Montana living in camps. So that's the analogous situation. Okay, so is there apartheid in Israel-Palestine? Point 5. Richard Goldstone, former judge of the Constitutional Court of South Africa, published an op-ed in the New York Times in 2011, which he entitled The Apartheid Slander. And you'll see here, he said, the charge that Israel is an apartheid state is a false and malicious one that precludes peace and harmony. Now, he made 2 arguments. One, apartheid is intended to be permanent. South African apartheid was intended to be permanent. Israel's occupation is temporary. Okay, well, the apartheid government in South Africa lasted for 46 years, from 1948 to 1994. The occupation is now 50. So it's hard to see that difference. The second point he makes is that some Palestinians, around 25% of those living under Israeli control, have the right to vote in Israeli elections. Now, the Palestinian citizens of Israel are a category that did not exist in South Africa, and I describe them as Israel's democratic fig leaf. So this is what people always point to. How can you call it apartheid? But the point is that the racial discrimination in access to citizenship and the right to vote doesn't have to be perfect. So if it's only 75%, it doesn't change the nature of the practice. Okay, page 4. So if there's apartheid in Israel-Palestine, when did it start? Most commentators, including Ehud Barak and Ehud Olmert, always talk about the future. This will be a situation of apartheid if there's no two-state solution. The New York Times talks about the day when the Jewish population will be smaller than the total Palestinian population. Well, the two-state solution seems to have died in 2014. Mr. Netanyahu won re-election, promising that there would never be a state of Palestine. So that needs to be taken into account. But I argue that we have to go way back, and I'm sorry to have to break the bad news, but my diagnosis is that the apartheid started in 1948. And by coincidence, the apartheid government in South Africa was elected in May 1948. Israel was founded in May 1948. What is going on in the world at that time, post-Second World War? We have the start of a trend against racial discrimination. In fact, also in May 1948, you get a US Supreme Court decision, Shelley versus Kramer, on racially discriminatory restrictive covenants attached to land, which said basically you couldn't sell your house to an African American. So what happened in South Africa was what I call self-declared and unapologetic apartheid. South Africa said to the world, no, we are never going to follow this trend. The black majority here will never be full citizens, will never have the right to vote. On the other hand, they're most welcome to stay because we really like their labor in the mines, on farms, in our gardens, in the kitchen, etc. So that's the South African version. Now, Israel's founders had high ideals. They were trying to establish a Jewish majority democracy, but the complication is they were trying to do it in a territory where there wasn't a Jewish majority. So how do you make the numbers add up? Well, the term you tend to hear is Palestinian refugees. And I would propose that we change this to expelled Palestinians, because the word refugee tends to put the blame on the Palestinian, saying, it's all your fault. You fled your home. You should have just stayed there. So there was shooting nearby, you know. You should have just stayed put. You left. You were seeking the destruction of the new state of Israel. So it's tough luck. It's all your fault. But certainly the UN General Assembly did not agree with that in December 1948 when they passed a resolution on the right of return. And in terms of causation, we have to ask, so what is the last factor that prevents them from living in Israel? It's the government of Israel slamming the door shut when they try to return. So I actually think it's irrelevant why someone was outside of the territory at that time. They were legally resident there, and they had a right to return. So why did this happen? Well, I took the first census of Israel from November 1948, and I just added back, this is the table in the middle of page 4, just added back the United Nations total of 711,000, what I would call expelled Palestinians. And what happened? Suddenly you have an Arab majority state with a 55% majority. Now imagine that was reflected in the legislature. The Arab members of the legislature might have said, well, actually we like the old name, Palestine, and we'd like to change it back. And we have lots of friends and family in the West Bank, East Jerusalem, and Gaza. So why don't we talk to Egypt and Jordan? Let's just bring it all back together again. So, of course, that was not what the founders of Israel had in mind. Here's a hypothetical question. What if if everyone had stayed put? Because there was a big difference in the number of people fleeing in 1967. There were still a large number of expulsions, but Palestinians knew that they should try not to leave. What if everyone had stayed put in 1948? Well, maybe Israel would have had to go down the same road as South Africa and just say, well, we wanted a Jewish majority state, we've got it, and the way we're going to achieve it is by denying the right to vote. So at the bottom of page 4, top of page 5, you have a quotation from Daryl Glaser, a South African scholar. And his conclusion at top of page 5 is, it is difficult to see how achieving a majority by expulsion and flight is morally superior to obtaining one by the simple disenfranchisement of people in situ. I've spoken with a Jewish Israeli boycott activist, Ronnie Barkin, and he describes the Jewish majority of 1948 as an artificial majority created by force. So I argue that apartheid in Israel-Palestine has 3 components: the expelled Palestinians, which includes their children, grandchildren, etc., who are continually denied citizenship of Israel and the right to live, work, and vote in Israel because of their ethnicity. The occupied Palestinians, who are similarly not citizens, and the second-class citizen Palestinians, who are citizens of Israel but subject to various forms of de jure and de facto discrimination. One point here, Omar Barghouti, in his book BDS, has 3 terms and 3 demands. So he talks about Palestinian refugees, right of return, occupation, respect the right of return, occupation, end the occupation. Palestinian citizens of Israel, it's apartheid, end the apartheid. I disagree with him about this, and I wrote to him because I think he's attaching to the word apartheid only to the group that's in fact in the best position of the 3. So if there were a magical 2-state solution tomorrow, I would not use apartheid to refer to the situation of the Palestinian citizens of Israel. But it is, I consider it a component of the system, because you have to remember the only reason they have citizenship and the right to vote is because their numbers were reduced through expulsion to a tolerable level. Okay, I'm going to skip over the part on security. You can read that for yourselves. In my article, I conducted a thought experiment where I imagined that Israel had become a member state of the Council of Europe and the European Convention on Human Rights applied, and Palestinians could take cases to the European Court of Human Rights. By the way, the court applies the principle of effective control, so they would consider violations taking place in East Jerusalem and the rest of the West Bank and in Gaza. So it was very interesting to take the case law of the court and map it onto the situation there, and there was quite an interesting fit. The European Court of Human Rights has supported the right of return with regard to Cyprus and Armenia and Azerbaijan. So I came across a recommendation by a Jewish Israeli lawyer, I'm not sure, that Israel should apply for membership of the Council of Europe. I think if he reads my article, he'll change his mind. Okay, so that's what you've heard is a refined version of my first talks. Now I'll just quickly say something about the B word. So is boycott justifiable? Well, I would argue it is, because the situation legally is unique, the refusal to grant citizenship and the right to vote. It's very hard to find similar situations around the world. One would be the treatment of the Rohingyas in Myanmar, who are being denied citizenship on ethnic grounds. But in Dominican Republic, there's a question of citizenship for persons of Haitian origin, but there are very few similar situations. And the second unique feature is the support of European and North American governments for the government of Israel, which involves the mildest of criticism. So compare, for example, Russia's annexation of Crimea in 2014. There were sanctions within months. Israel annexed East Jerusalem not long after the 1967 war. Resolutions in the UN Security Council saying this is illegal, invalid, etc., but no sanctions. Okay, so is it hate speech to advocate a boycott of Israel? I would argue that it's not. We have a precedent from the US Supreme Court. There's an error on the handout. The case year is actually 1982, not 2000. National Association for the Advancement of Colored People versus Claiborne Hardware. So you had a situation where African Americans in, I can't remember whether it's Mississippi or Alabama, organized a consumer boycott of what they considered racist white merchants. And eventually the NGO, the NAACP, was facing huge liability for the losses suffered by the merchants. And that, I think it was a decision actually of the Supreme Court of Mississippi, was overturned by the US Supreme Court. And you see the quotation here, they say, a nonviolent, politically motivated boycott is constitutionally protected. Well, there's a similar issue now in France. 11 BDS activists went to a supermarket in eastern France. They were wearing T-shirts and handing out leaflets that said, boycott Israeli goods, which was all peaceful. They were charged with inciting racial discrimination. The trial court acquitted them, saying the legal elements of the offense were not there. They were convicted by the appellate court, and the convictions were affirmed by the Cour de Cassation, the highest civil court in France. It's now pending before the European Court of Human Rights. So we'll see what they have to say. Okay, so that's advocating boycott, and then there comes the question of actually doing it. So I'm now on page 8.12. So an individual could decide that they're not going to purchase goods made in Israel, oranges, dates, figs, avocados. Not that this is going to have a huge impact on the economy, but anyway, that they're not going to go there as a tourist or for an academic conference or to compete as an athlete. There were some African American NFL football players who were offered a free trip to Israel, I think for winning the Super Bowl, and publicly declined it. And there's the question of artists, whether they should perform in Israel. Well, this is actually going to be my next article. This is it hate speech? Does it violate? To advocate boycott, does it violate anti-discrimination law to actually do it? And my tentative, let's say my hypothesis, until I think about it carefully and do more research, is not hate speech, and generally anti-discrimination law does not apply. Because anti-discrimination law is usually asymmetrical. It applies to the provider of an opportunity, an employer, a shop selling goods, a website providing services, a university providing education. It does not apply to the consumer who is choosing. So if you're choosing what goods you buy, where you go on holiday, which conferences you attend, etc., it should not apply. Now, the distinction is consumers at French supermarkets have the right to go in, see goods saying made in Israel or made in the West Bank. There are different versions of the boycott, and say, no, I don't want to purchase these. Anti-discrimination does not apply. If the supermarket puts up a sign saying, in solidarity with Palestinians, we do not employ citizens of Israel or permit them to purchase goods here, that is a clear violation of anti-discrimination law in France, the UK, Canada, USA, everywhere. So you have to be aware of what is permissible. Right, I just kind of want to end on a historical note. Something I was just thinking about this morning, the way in which Canada could help the situation in Israel-Palestine. And I think I would call it humility. So I haven't really been following the whole process of the Truth and Reconciliation Commission in regard to residential schools, but a great tragedy. And I hear a lot of discussion about that, but that's all I hear. And actually, I think the starting point of the discussion in Canada, and I would love to propose to Prime Minister Justin Trudeau that he do this, would be to say, sorry, we shouldn't have come here at all. We had no right to do so. We had no invitation. I was taught in my Canadian elementary school about brave explorers sailing across the Atlantic. It's discovering empty lands. Well, I think, being honest today, you'd call that an invasion. So I think that's the starting point, to say, sorry, it was a historical wrong, it shouldn't have happened, but now we have to find a way to live together. And if Canada could do that, then I think Jewish Israelis and their political leaders could do it. And the starting point, I would say, is 1917-18. So the average liberal Jewish Israeli law professor thinks that 1967 is a big mistake, occupation is bad, it should end tomorrow. They don't want to talk about anything before 1967, not 1948, and definitely not 1917. The Balfour Declaration, 2nd November 1917, 100th anniversary coming up. Now, the population of Palestine, when Britain conquered it and took it from the Ottoman Empire, was about 92% Arab. So how do you get from a 92% Arab majority to the State of Israel? Well, here the missing link is abuse of power by the British Empire. So the British Empire agreed with the Zionist movement that, yeah, it's a good idea to get Jewish minorities out of Europe. Why? Because we're getting too many Jewish refugees from Russia and Britain. So your idea of diverting them to Palestine, great one. Yeah, we're all with you on this one. So that's a racist feature of the Balfour Declaration. But in any case, this immigration was allowed to happen against the will of the people there. No one asked them, there was no referendum, etc. So my challenge would be to Jewish Israelis to go back to 1917 and say, yes, there was a strong case for a Jewish majority state somewhere in the world, but on land donated by a Christian majority country. Palestine had nothing to do with our persecution in Europe, and they should not have been made to pay the price of compensating us for past wrongs. So if they could take that as their starting point, actually, we shouldn't have come here. It was wrong. But now let's figure out a way to live together. Thank you.
We have quite a bit of time, and I'm going to ask Rob whether or not you prefer me to direct traffic, or are you happy to take them as they come?
You might be better at spotting them, so why don't you do that?
I have a better eyesight. Okay. All right. So the floor is open for questions. Anybody want to start us off?
This is just like teaching.
We'll start with Professor Fleisig.
Thanks for a really interesting talk. I guess I want to pick up on the one thread that you didn't develop, and I commend you for developing lots of threads and weaving them together really effectively and beautifully in your presentation, which felt a lot shorter than it was. I think I looked at the time. But you left it dangling, and it troubles me, is your refutation of the claim of apartheid for the Palestinian population inside Israel. It seems to me that the argument you make for applying that description to the population of the occupied territories is strengthened by acknowledging a system of apartheid internal to Israel. I mean, even just on the historical record, I mean, from 48 to 67, they were treated, they were subject to direct military rule, which evolved into a long-term essentially a long-term occupation slash annexation, which I think is your central claim.
Mm.
Long-term occupation stops being an occupation, and that's exactly what happened inside Israel. In the case of that population and where we are today,
Mm.
might be a vision of where of where Palestinians in the occupied territories want to end up. But looking at that as analogous and can, I think, strengthens your overall claim.
Mhm.
I'm just wondering why you want to.
Well, the first reason is that Omar Barghouti, in his book, tends to use the apartheid term only with regard to the Palestinian citizens of Israel. The study Beyond Occupation, edited by Virginia Tilley, analyzes only West Bank, East Jerusalem, Gaza, and talks about it as a situation of apartheid. The recent study, which is in my pile of reading, which I haven't had a chance to read, by Professor Richard Falk and Virginia Tilley, extends the analysis to all, I think they include expelled Palestinians, but they include the citizens of Israel, yeah. So I suppose my objection is to attaching it solely to that population, and also to failing to recognize that they're actually, in the hierarchy of Palestinian suffering, they're in the best position. So I don't want to use a shocking term, but if you go back to the southern US and you compare perhaps situation of African slaves employed in the house versus the fields. I probably know Palestinian Israelis would object very strongly to that term and that comparison, but they do have Israeli passports and they're free to travel the world. People in the West Bank cannot leave. If they're deemed a security threat, they cannot go to Amman airport. And if you're living in Gaza, it's very hard to get out. And once you're out, it's very hard to get back in. So that's the only, but it's an essential component of the system. So I just try to just suggest that it's serious, but not as serious.
Can you follow up? Yep. I think you're acknowledging how slaves are still slaves. That's the key descriptor.
Mm-hmm.
Raif Zurek argues that it can't be apartheid and colonialism at the same time. Do you think maybe that's the explanation for why Barghouti and others take the position that they do, that you have colonialism in the West Bank and Gaza, and therefore it can't be apartheid, because the solution for apartheid is one state, he argues, and the solution for colonialism is an independent, separate state.
Okay, that's something I didn't touch on. I would say colonialism and occupation are going down one track because they're contemplating withdrawal and a two-state solution. One reason I don't use the word colonialism, or especially settler colonialism, because there tends to be an implication that the settlers should go back where they came from. Now, nobody says that in Canada, the US, Australia, New Zealand. It didn't happen in South Africa. I think I skipped over my part on Algeria, where it did effectively happen. Most of the settlers went back to France because of violence. So I should be clear that Jewish Israelis have a right to live where they are now, and there's no question of them being pressured to move anywhere else. So that's why I don't use the term colonialism. But I don't think that using the word apartheid means necessarily it has to be a one-state solution. There's a difference. If you look at South Africa, I don't think anyone ever proposed a viable two-state solution. You had a white population scattered across the country, owning mines, farms, all over the place. Theoretically, they could have said, okay, we're reversing the Great Trek. We're going back to the Cape Town area. This will be ours, and you have the rest of the country. But I never heard of any such proposal. So the fact that there is the option of going back to the 1967 borders is why the BDS movement in particular says that it is neutral as between a two-state solution and a one-state solution. That's in theory, but the problem is in practice, many activists would say, Israel has made a two-state solution impossible, including Jeff Harper, who's is or was director of the Committee Against House Demolitions. He spoke at a conference in Cork in Ireland in April, and his slide said that he supported BDS for BDS, boycott, divestment, sanctions for a binational democratic state. So I would say that's the default position until Israel comes up with a good faith, just proposal for a two-state solution. But I think politically that unless we talk about apartheid and boycott and the possibility of one-state solution, there will never be such a proposal. Because what we have at the moment is, we have the possibilities of a two-state solution with Israel remaining a Jewish majority state and becoming finally democratic, you could say, subject to negotiating the right of return, and a one-state solution, one democratic state along the South African model. Those are the two options in the future, and what we have is an apartheid status quo. But the status quo is very comfortable for Jewish Israelis. The two options in the future are uncertain, involve risks, so they're quite happy to stick with the status quo, and that's why many Jewish Israelis will say, we will not change on our own. We need help. We need external pressure.
Any question?
It was really more of a clerical thing. You mentioned a decision by the High Court in England regarding the admission of a Jewish child into a Jewish school. I forget specifically how you framed that in terms of ethnic or racial issue.
Well, remember, racial is defined very broadly. It includes ethnic or national origin, color, etc. But yeah, the majority found direct discrimination on racial grounds. One of the opinions was written by the first president of the UK Supreme Court, Lord Nicholas Phillips, who now has an office in the School of Law at King's. And I recently, through his assistant, gave him a copy of my article pointing out that I've cited him. So I haven't heard from him yet. He might say, oh, no, you got it completely wrong. I would never take that analysis and apply it here. But I haven't heard from him.
So the area of clarification that I suppose I would go towards in that situation, and maybe you know more about the case than I do, is that Judaism has three different sects of religious observance: Orthodoxy, Conservative, and Reform, that are sort of widely accepted.
Mm-hmm.
And so I'm wondering if this Italian woman, Judaism is passed down to the mother, if she had converted to, say, the level of religious observance that that school had recognized, and if that was a consideration of the court in this case.
I think she had not had an Orthodox conversion. I think that was the problem.
And so would that not be considered a religious form of discrimination as opposed to a racial one?
Well, you can. That's true that there are ethnic and religious criteria operating in this situation, but the decisive one, well, question one is, under religious criteria, has your mother been properly converted to Judaism? No. Question two, do we consider her to have been born of a Jewish mother? No. So it's really the second one they're focusing on. Yeah.
Okay.
So the Jewish grandmother was missing, I suppose you could say.
Was the state-funded school have a specific branch of Judaism?
I think probably Orthodox, but I'm not sure. Mm-hmm.
I have two things, actually. I wanted to follow up on this case. I don't know any details about the case, but was this just was it refusal of acceptance into the school or refusal of citizenship in Israel? Because
The UK Supreme Court case?
Yeah.
Oh, it was acceptance into a school in the United Kingdom. It had nothing to do with Israel.
Okay.
Yeah.
Because certain streams of Orthodoxy and Judaism, I think most secular Jews would agree that they do tend to discriminate against many, and I don't think it's very representative of the Jewish community as a whole.
Mm-hmm. I refer to it more as just an example of using ancestry as a criterion. Now, in fact, Israel's immigration law is more generous because I assume in Orthodox Judaism they would say it's your mother who has to be Jewish. And as I understand it, Israeli immigration law says either parent can be Jewish or one of your 4 grandparents. So that is much broader.
Right.
Mm-hmm.
And then my other question was back to, and you didn't have a chance to discuss it, on security.
Mm-hmm.
So you wrote that there is no evidence that if there was a 2-state solution, there would be no retaliation. I don't know how you phrased it, I don't remember.
Yeah. It's on page 5. Yeah. Maybe I should just turn to that file just to explain what I mean. So this actually was a result of my presenting my thoughts at King's College London to a staff seminar. And the chair was my Jewish-Israeli colleague Irit Samet. And this was just a few months after the conflict in Gaza in the summer of 2014. So she said, what about our security? That was her comment. And I said, okay, I'll take that on board and I'll include something. And when I thought about it, I thought, well, generally speaking, security of a nation, of a group, does not justify racial discrimination because if you think about proportionality, Supreme Court of Canada, what do they call it? Minimal impairment, is that criterion? Are there alternative means? You could almost always find alternative means based on individual conduct. So you apply rules to people who have been involved in violence in the past, or there's reason to think they've been involved in the future, but you cannot categorically exclude an entire group based on ethnicity. And the case I cite is, well, you see it at the bottom of page 5, is Korematsu versus United States. So we have to recall North American history. US and Canadian citizens of Japanese ethnicity were put in internment camps solely because of their ethnicity. All of them were presumed to be potential saboteurs. We might call them terrorists today. And that was upheld by the US Supreme Court, and it's considered one of the worst decisions ever of the US Supreme Court. And there's since been a government apology and compensation, et cetera, a monument in Washington, D.C. So that's the starting point, that generally speaking, most of the rules that you would challenge and say this involves racial discrimination, just passing through the wall, for example. If you're Palestinian, you need a permit. If you're Jewish Israeli living in a settlement, you whiz through like you're going through a toll on the highway. So how do you judge? Well, the justification is, well, every Palestinian living in the West Bank is a potential terrorist. We have no choice. And well, outside of Israel, most people would say, well, that is disproportionate. You have to restrict these measures to individuals. And the second point I came up with was that the security justification is not persuasive if it's actually the racial discrimination that causes the security problem. And that's what that's a question I think most Jewish Israelis never ask themselves. So rockets are being fired from Gaza. Why? So the reaction tends to be these crazy Palestinians. They're so violent. They keep attacking us. What have we ever done to them? Okay. Well, if Jewish Israelis were living in Gaza under those conditions of being cut off from the entire world, limited electricity, contaminated water supply, et cetera, maybe they would fire rockets over the wall too. So I think that's something to be considered.
So I agree that the majority of Palestinians are innocent and suffering. But when you have leadership who is promoting violence and promoting the destruction of the country of Israel, and they say that they will not stop their violence until the country ceases to exist, how do you propose a 2-state solution? Because it sounds wonderful, and but when you actually act on it, how do you propose going about it?
Well, I think it would involve Israel taking the moral high ground and saying, okay, sorry, what we did was wrong. We're now withdrawing. Okay, you have your state. But I mean, it has to be on agreed. There's so many stumbling blocks. They don't want to go back to the 67 borders. They don't want to give up East Jerusalem. They don't want the state of Palestine to have its own military. They want to have security control in Jordan Valley. It's so hemmed in with conditions. But if you took all that away and said, no, we're giving you everything you want, it's going to be like May 1967. But if you send a single rocket over the line, we are going to pound you. Now, in that situation, if a conflict erupted, I would say self-defense. The racial discrimination has come to an end, and it's up to the new state of Palestine to rein in the militants.
But I wonder if
I think we need
Yeah,
to,
sorry.
I think we need to move on. Thank you for those the probing questions. Did you have a question?
Thanks for your talk. This was brilliant, and it's very encouraging to have talks like this at the school, I have to say, so thanks to organizers. I'm wondering, in North American context, considering that you're an anti-discrimination lawyer, I think we're seeing more and more this kind of rhetoric and language of anti-discrimination being used to silence criticism of Israel and to suppress kind of advocacy for basic human rights for Palestinians. So I'm wondering, in your analysis and in the way that you're kind of looking at different parallels, we're seeing more and more things, especially in the U.S., where there are, student groups are being sued and they're being completely silenced, and those issues are starting to be taken up in civil courts. I mean, what would you think, or what might you propose to students and activists who are looking to kind of help people to actually understand the context, and how would you respond to this kind of bizarre, like twisted anti-discrimination language that's being used to silence conversation and dialogue?
Thank you. That is an important question. I had lunch with the McGill campus coordinator of Independent Jewish Voices Canada on Monday, and she was saying that there's a committee within the McGill Student Society that has interpreted the McGill Student Constitution as prohibiting the society from supporting any boycott against any country, any in the world, except in extreme circumstances. They've just sent me the opinion. I haven't had a chance to read it, the arguments, the justification seems to be, and they say Israel-Palestine is not extreme enough, and this has to be done because Jewish students on campus would be marginalized. Okay, now that is, I think you're absolutely right that concepts of anti-discrimination are being distorted. Remember, they're about exclusion from opportunities. They don't mean being protected from opinions you disagree with. So there has to be a vigorous defense of freedom of expression, but some student activists who support Palestinian human rights might have to reconsider some of their position on some other campus speech issues. So they don't like someone they consider anti-trans, and they say cancel the event, it mustn't take place, etc. So it cuts both ways. So if you want free speech on Israel-Palestine, you're going to have to allow it and allow opinions you don't like on other issues.
Having conducted a sit-in of the McGill Board of Governors 32 years ago for divesting from apartheid in South Africa, I find that development just a little bit, I'm not sure if it's 30 years of progress at all.
Was anyone worried about marginalizing white South African students on campus?
No.
No.
That's great. Thanks so much, Rob. It was a terrific talk. I'm wondering if you could share with us a few thoughts about how you think about the connections between the legal arguments you've been developing in this talk and in your paper and the politics of transformation towards a binational democratic resolution of the conflict in Israel-Palestine. Because obviously it's of great value. I'm certainly interested in hearing the legal arguments developed on it for their own sake. But you commented earlier to transform an occupation into an illegal occupation isn't likely going to change things. I presume you've spent a career making legal arguments that you believe firmly were going to lead to important transformations in the world as we experience it. I presume you think the same thing about the arguments you're developing here, that they have the potential to contribute to a peaceful transition to a binational democratic solution in Israel-Palestine. So I'm wondering about that.
What's
because part of me
law
wants
got-
to sort of say, well, you know, to
Yeah.
call systemic discrimination apartheid, is that going to change things?
Yeah.
I mean, is the BDS movement, does it have the potential? Now, obviously, you're interested in the legal analogies to South Africa. I assume you're also interested in the political comparisons, but I don't know, maybe it seemed hopeless for anti-apartheid activists in the 70s and early 80s, and maybe we're a similar future lies ahead, but it's certainly hard to be optimistic from where we sit, and certainly hard to be optimistic about the legal arguments making a significant
Yeah.
difference.
Okay, well, thank you. To evoke Tina Turner, I think your question is, what's law got to do with it? And I actually got that question from my colleague David Nelken at quite an early stage. It was very helpful, and I incorporated it into the introduction because it isn't obvious. And I think the contribution is that legal arguments can inform political arguments and political debate. And the situation we have today is governments of the European Union and Canada and the US will say Canada and Israel share common values. Okay? Is racial discrimination in access to citizenship and the right to vote a Canadian value? Okay? I think that is the value of adopting this analysis and using it in lobbying, it's campaigning with governments, is to point out the inconsistency. You're backing something you say you don't agree with. So I think that's where it, I hope, will add some value. Now, I like that you mentioned the word hope, or the situation being hopeless. Okay, this is where I draw on my long experience working on LGBT human rights. So let me give you some examples. I moved to the University of Oxford in 1987 to start my PhD. 1988, the UK Parliament passed Section 28 of the Local Government Act, which prohibited local governments from promoting homosexuality, and specifically the teaching in state schools of the acceptability of homosexuality as a pretended family relationship. Okay? So pro-LGBT expression was seen as very threatening at the time. Progressive local governments had what they called positive images programs, and Margaret Thatcher in the central government said, no, we've got to stop this. And Russia adopted a similar law in 2013. So that was where we were then. Could I foresee that in 25 years there would be same-sex marriage in England and Wales? Not at all. And 1993, I finished my PhD thesis. I sent it to Oxford University Press. The first reviewer rejects it. She says it's biased. So I was allowed to write a response, and I said, I disagree with the reviewer. The reviewer's idea of neutrality is, my starting point is supposed to be, should LGBT persons be put in concentration camps? Or should they be granted equal rights? That would be neutrality and non-bias. So I was lucky they looked for another reviewer, and then they published it as a book, Sexual Orientation and Human Rights. So bias. And then 1999, the conference you mentioned, Legal Recognition of Same-Sex Partnerships, triggered a petition, an email petition signed by over 160 law professors from around the world, saying the conference was not balanced. The traditional view of marriage had not been represented. Okay? So I know things can actually change quickly, and that just because it seems hopeless doesn't mean that you're not going to get there in the end, when you have a just cause, and that's what you always have to remind yourself.
If I could just follow up, and I think see if anybody else has something to say, put your hand up. We still have 10 minutes. It's a bit of a follow-on from Bruce, and the idea that, unfortunately I haven't read your Keynes piece yet, so this may have been addressed. But the idea that there is some consistency in your analysis and your prescription for some form of say, binational democratic state. The interesting thing that I notice in Israel itself is that the word apartheid does get used a lot, all the time, by very senior, thoughtful people in the middle of the state apparatus. So you mentioned Omar and Barak. Mayor Duggan, the former head of, I believe it was Mossad, might have been Shin Bet, also came out with scathing analysis about 4 years ago to say, this is where we're heading in terms of anything resembling either deepening of the de facto situation or certainly deepening it so much that we have no choice eventually but to acknowledge a one-state solution. And the only thing that we can thereby do if we also want to maintain the Jewish side of the Jewish democratic state is to actually formalize apartheid. And so I'm not sure which comments you were talking about with Barak and Omar, but my experience with the higher level people using this word, it's a projection and a prediction where their solution is two-state solution.
Mm-hmm.
They're saying it will come. They don't yet knit it together in the kind of the de facto borderless analysis that you're doing. So it's consistent. There's nothing wrong with them having said that, if we formalize it, that will be apartheid.
Mm-hmm.
But do you see any, if you have leading voices in Israel making that argument that's more future-oriented, but a warning, strong warning, and it's been going on for about a decade, deepening in the last 5 years, their prescription, two-state, your sort of, I think the logical outcome is closer to some form of a binational confederate style, confederal style, single state. Where do the two voices using the apartheid analysis meet on that, the big prescription?
I think, as I said before, I'd say the ball is in Israel's court. They have the power, and they have to choose between maintaining the dream of a Jewish majority state or allowing Jewish Israelis to live anywhere they want in the historical land of Israel. So they want to be able to live in Hebron and et cetera, Judea and Samaria, as they refer to the West Bank. You can't have both. So they will have to choose. Now, because there are so many settlers, people say that the main water sources are underneath the West Bank. It's hard to see how a two-state solution is possible. So I don't think I've mentioned my visits to South Africa. I went in 1995, the year after the first elections, and there was a lot of white emigration at the time, spiraling crime rate, a lot of anxiety. When I returned to London, I didn't know what the future held for them. I returned in 2014 when they were celebrating 20 years of democracy. And I can report that white South Africans are alive and well. The population. Sorry?
The rest of the population is the question.
Yeah, that's a big other question. But the population is about 90% of its peak. So yes, there has been emigration to Canada, Australia, UK, etc. But there's still a very substantial population there, living very well on the whole. And I would say now with a clear conscience. They have a good constitution, a constitutional court, etc. Not so clear about the economic disparities, which are easily overlooked. When I was there, actually, my friend was grumbling, my host, about electricity shortages, the power being turned off in certain neighborhoods. And I didn't say it. I was trying to be polite, but maybe I could have said maybe the system is overloaded now because black South Africans are getting electricity. So white South Africans didn't have experience of power shortages, so they were grumbling. But I think it could be made to work because Jewish Israelis, it of course depends what would happen with the right of return. There may be many expelled Palestinians who don't want to return, especially if they're living in Canada, Australia, Dubai, who knows where. They may just want an apology and acknowledgement to the wrong, some financial compensation for any property they lost. But let's imagine a situation where the population is roughly 55% Palestinian, 45% Jewish. Well, in South Africa, the white minority is 8 or 9% of the population. So I would imagine that a 45% Jewish minority could fend for itself. It would be economically dominant. And in my article, the proposal I throw out is if we had a single state, the world would have to reassure Jewish Israelis, we're not abandoning you a second time. And I think one way to do that would be to propose that the new single state become a member state of the European Union and a member of NATO and a member of the Council of Europe. The European Convention on Human Rights would apply. You'd have freedom of movement, etc. So I would think that combination of guarantees might actually work. But stage one is for both sides to get their minds around the idea that there's no alternative. Now, on the Jewish-Israeli side, the reaction tends to be, there'd be civil war. They'd kill us all. I understand those fears, but that's what white South Africans said for many years. On the other side, I'm told that Palestinian support for a two-state solution is dropping and support for a one-state solution is rising. But there's still some people who don't want to give up the dream of their own state. I witnessed this in my office at King's. I had two Palestinian law students from Al-Quds University, and I threw out the idea of one-state solution, and they were horrified. What? You mean we're going to have to live together with those people in the same country? Oh my God, we've been trying to get rid of their rule for years, and now we have to share the country. So, I mean, that's an unscientific sample of two. But on both sides, you have people who just have not even consider it unthinkable. So it's going to take a long time. But just based on my experience with LGBT human rights, I'd say Palestinian human rights are about 30 years behind. So fast forward 30 years, we might be in a different position.
Great. I think we have come up against the 2:10, and I'd like to thank Robert so much for an amazingly elegant and precise talk, and looking at issues from multiple perspectives while sticking to your own guns is exactly what we were hoping for. And you don't have to open it here, but a small token of our appreciation. Now that you have an extra day, you can while it away with the Nathanson Center mug. Sitting in some cafe, and probably I'd recommend downtown Toronto, not necessarily on campus. So thank you so much.
Thank you.